I'm going to sentence you in that case to a term of 5 years in the institutional division of the Texas Department of Corrections.
This is one of those cases that quietly walks into a courtroom and then completely changes the air once the details come out. At first glance, it sounds procedural, plea agreements, caps, probation talk. But what you're about to hear isn't just legal bargaining. It's a judge trying to figure out how to protect the public when trust inside a family has already been broken.
All right, sir, you are Robert Lowe.
Yes, ma'am.
And in cause numbers, okay, so we were here before, and Mr. Lowe had entered pleas of guilty in cause numbers 19, 32661, 32662, and 32663.
Yes.
There was an agreement that you guys had reached for a 7-year deferred probation. I rejected that plea agreement. We reset it. He went back through, entered pleas of guilty in those same cases open to the court, correct?
This is where things get uncomfortable and, honestly, complicated. You're hearing the defense talk about forgiveness, about time passing, about a family asking the court not to send him to prison. And that always creates tension. Because forgiveness inside a family doesn't automatically erase the risk outside of it. Courts don't just punish, they have to prevent.
Correct?
It was a cap of 6.
Cap of 6. Sorry. Cap of 6. And it's the same 3 cause numbers as well, correct?
Yes, Your Honor.
Okay. And then the agreement was for dismissals in the remaining cases as part of that agreement. Is
Yes.
that right also?
Yes.
And we reset it after that plea without getting a new pre-sentence report. We've already all gotten the pre-sentence report, reviewed that. Is that correct?
Yes, Your Honor. And we received a memo. Well, it's the same pre-sentence report. We just have an updated memo from the mother of the one of
Victim.
the people that he had photos. One of the children.
Yes. Okay. And I reviewed that as well. Did you have an opportunity to review that?
I do not see, give me just 1 second.
Yes, ma'am.
Sorry. I've reviewed that in the original PSI. Obviously, the court is aware I was not involved with offers in this case.
Okay. Thank you, ma'am. Any reason not to go forward now with sentencing?
No, Your Honor.
All right, Ms. Holmes, you may proceed.
Yes, Your Honor. We are still requesting that the court consider probation in this case. We do know, obviously, the offer of deferred probation was rejected, but we would like the court to consider possibly straight probation in this case. Mr. Lowe does not have any previous criminal history. One of the victims or complainants in regards to photos was his niece, in which I have been in touch with her mom, who is Mr. Lowe's sister, Brittany Lowe, in which I'm aware, the court is aware that they both submitted statements in which they are requesting that it appears that he received some type of probation, in which they're not requesting that he be sentenced to time. But they are obviously requesting if there's a no contact, which we believe is appropriate, and any other stipulations. So, Your Honor, we are asking that the court consider straight probation possibly, maybe the 6 years probated for 10 years, just to make sure that Mr. Lowe has a watchful eye on him to show that he can abide by the rules and regulations of the court. This offense did appear to be back in 2018. I will say to Mr. Lowe's credit, it doesn't appear that he'd have been in any trouble since that time. There were no new cases filed or anything like that. So I would say to his credit, within the last 7 years, that he has not committed any additional offenses. He does take full responsibility for his actions in these cases, and he's aware of what the possible maximum punishment will be. But I do believe that he can stay on the right track. The plan, if released and placed on probation, and that he will continue to live with his mother, who's 80, in her 80s.
I'm sorry, she's 73.
73, okay. She calls me quite a bit. But the plan will be for him to reside with her, which there are no children in that home. His sister and nieces, nephews live in separate locations. And so we're just asking that he be given that opportunity.
Now listen closely, hey, because this is the moment everything pivots. The judge isn't focused on paperwork anymore. She's focused on who was harmed and how. When the victim is your own niece, the law doesn't just see a crime, it sees a breach that's almost impossible to ignore.
Ms. Malfino, I know you're just stepping in. Obviously, I have a lot of information that I've gone through with all of this. Do you have anything to add?
No, Judge, other than certainly I'm understanding of the court's hesitancy for the original probation offer, which makes it difficult for me to stand and argue for probation at this juncture. I appreciate the statements that they emailed in. However, due to the nature of the offense, my position would probably have to be pen time, Judge, or in lieu of that, maybe some type of a hybrid, whereas he goes to the pen in one and is on a lengthy probation on another. I know the
When a judge uses words like ludicrous, that's not emotion slipping, that's credibility collapsing. Courts care deeply about responsibility, and excuses that minimize harm do the opposite. This is where the judge makes it clear. Treatment matters, but accountability comes first.
I know the court's
You read
that's
my
not
mind.
your favorite thing. So, based on everything you know, Judge, I'll defer to what you think is best.
Okay, thank you, Ms. Malfino. So I do want to make sure we're all on the same page, and I have done different types of hybrid sentencings before. But the first thing I want to make sure is everybody agrees with me legally that if I give probation on any of the cases, straight probation, that I can then give a 10-year sentence probated for 10 years, for example. Because it's probation, then that cap at the end, we've looked into that. So I want to make sure everybody understands and agrees with that.
Right.
So, Mr. Lowe, you know, I've already gone through at when we were here for sentencing before, obviously my issue with the plea agreement and the fact that it wasn't, not that possession of child pornography is in any way okay, it's not ever. But the fact that you actually took pictures of your own niece is the problem that I have. The initial version that you gave, it sounds like you finally came around and told at least somewhat of a truth, but the initial version of I was trying to protect children is just ludicrous, and makes no sense at all. So that gives me some great concerns. Obviously, if I just gave you prison time, I don't know that that gets me where I would like to be, because I think you need some treatment as well as probably some time, both. Because I want everyone protected if you are out or when you are out, because you'll get out of prison. So what I'm going to do in your cases, in cause number 19-32661, find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of possession of child pornography. I'm going to sentence you in that case to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then, in cause number 19-32662, also find sufficient evidence to find you guilty, and in that case, find you guilty of possession of child pornography. Sentence you in that case to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to probate that and place you on probation in that case for 10 years. In that case, I'm going to order a $1,000 fine and that you follow all of the rules and conditions of probation, which I'm going to talk about in just a few minutes. And then in cause number 19-32663, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. In that case, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 10 years. You'll be ordered to pay a $1,000 fine in that case and to follow all of the rules and conditions of probation. So here's what that means. First of all, you're going to do the 5 years first. Whenever you either finish that 5 years or make parole in that case, you're on probation in the other two cases for 10 years. And when you're on probation, what'd I do?
It's not 32663. That one, it's not that one.
It's 60, 61, and 62.
Yes. It's 32660.
Oh, the PSI is wrong. So the very last case that I just sentenced you on, which was 19-32663, I'm going to withdraw that. That was actually cause number 19-32660. And in 32660, I find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you to that 10-year term. It's going to be probated for 10 years, $1,000 fine. So with regard to those probations, once you're out of prison, you will be required to go through sex offender treatment. It will be a part of your probation. If you don't successfully complete that, participate in that, then it's going to be a violation and you're going to be right back in prison. And on those two cases, because I gave you probation, I was able to now give you a 10-year sentence instead of a 6-year sentence. So if you get out of prison and you get on these probations and you violate them, you already have a 10-year sentence. Do you understand? So whatever probation requires of you, but most specifically, the sex offender treatment part of this, you will be required to do. And if you violate, there's not going to be any second chances for not showing up to your classes or anything like that. My goal is going to be protect everyone around you and hopefully make it to where you have the treatment needed to where we don't have this issue again. Part of your probation will also be, in each case, that you're not going to be allowed to be around any child under the age of 18 unsupervised. And so you can't live with anybody that has children. You can't be, again, unsupervised with any child under the age of 18. Do you understand?
What's important to understand, Hay, is that probation isn't mercy, it's leverage. By probating those sentences, the judge actually extends the consequences. One mistake after release doesn't mean a warning, it means a decade behind bars. This is the court saying, we're watching closely, and we're not guessing twice.
Yeah. All right, I'm handing you in all three of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal in all three cases. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you.
Can I have something?
Yes.
The no contact with no unsupervised, can we wait till after treatment's completed and just be no contact?
Yes, so there'll be no contact with any child until the treatment is completed. And then after that, it would be as long as it's supervised. Okay? All right, go back with the bailiff.
This sentence isn't about revenge. It's about boundaries, prison time for what already happened, and strict supervision to make sure it never happens again. And whether you agree with the balance or not, one thing is clear. When trust is violated at this level, the court's first job becomes protection, not comfort.